Welcome back to This Week in Immigration. I'm your host, Jack Malday, Associate Director at the Bipartisan Policy Center. In this week's episode, BPC Senior Advisor Theresa Cardinal Brown discusses the Trump administration's actions to rescind foreign student status in the US with two experts. Steve Springer from NAFSA explains the roles of educational institutions, students, and the government in maintaining student status, and the implications of recent changes on international education in the US. Then, immigration attorney Charles Kuck talks about his lawsuit against the administration for rescinding the status of 17 students and the legal arguments involved. A very timely conversation, so stay tuned.
In recent weeks, the Trump administration has made efforts to revoke visas and rescind the status of hundreds of foreign students at educational institutions across the country. The process and rationale for these revocations and rescissions is somewhat unclear, and in most cases, neither the student nor the institution has been given any prior notice of the status change until the student is arrested by immigration agents. These actions represent a significant change in how the government and institutions have collaborated in the past to monitor the status of foreign students in the United States, and has put many international students and their educational institutions on edge. Today, I talk about this situation with Steve Springer, the Director of Regulatory Practice Liaison at NAFSA, the Association of International Educators. In this role, he manages NAFSA's engagement with federal agencies on regulatory practice issues. Before joining NAFSA, Steve worked as an immigration attorney, representing higher education institutions and their faculty, staff, and students. He also managed immigration services for several major research universities. So welcome to This Week in Immigration, Steve.
Thank you, Theresa.
So first, can you just tell our listeners about NAFSA? Who does NAFSA represent and what is its mission?
Sure. So NAFSA used to have a different name. We are now the Association of International Educators. So when we changed the name, we kept the old acronym. So that's why we're still called NAFSA. But we are the Association of International Educators, and we're one of the world's largest organizations committed to international education and exchange, with about 10,000 members in a variety of roles that include education abroad for U.S. students, and approximately 6,000 of the 10,000 members administer programs that bring foreign national students, exchange visitors, faculty, researchers, and staff members into the U.S. And many of these 6,000 are designated school officials. That's a term I'll use some today, DSOs. And they're the ones who advise F1 students and manage their data in the SEVIS system, the Student and Exchange Visitor Information System, which is just a database that tracks F1 students and J1 exchange visitors in the U.S.
Yeah. So you mentioned a bunch of acronyms there. So let's dive into this a little bit. Can you explain the traditional process for educational institutions in the United States to host foreign students in the U.S.? And we'll kind of go through those acronyms as we go here, probably.
Sure. Yeah, we do have our acronyms, don't we? So the short version of the process is that once a student has applied to a university, for example, or a college for admission and been admitted and shown proof of financial support to cover the costs of studying and living in the US. They usually show a bank statement or home government funding or something like that. So once those two things have happened, the student's been admitted to the school, shown proof of funds, then the advisor uses the Student and Exchange Visitor Information System, SEVIS, to issue the visa eligibility document that goes to the student. And with that visa eligibility document, the student goes to the consulate, applies for a visa, and if successful, uses that visa to enter the US. And once that visa eligibility form, and it's called an I-20, you may have heard of this before. Once that's created in SEVIS, the student's entire program is tracked in SEVIS. And I mean, the data that's tracked is extensive. I mean, it tracks home address, course of study, whether you're registered for a full course of study, major, all sorts of data that's put into the SEVIS system. And again, managed by the designated school official on the school side, but it is a Homeland Security database. So the Department of Homeland Security, manages the SEVIS database more broadly. But again, DSOs, the school officials, are the ones putting the data into it about the student.
Yeah. So let me ask you, can any educational institution in the United States host foreign students, or is there a process for an institution to get approval to do this?
Yeah, thanks. That's an important question. So no, it is difficult to be certified by the Department of Homeland Security to host students, and you have to go through a number of steps and a lot of vetting by the government. And then you also have to, you can be regularly vetted and overlooked by the government as you do your operations. And then every 2 years, you're required to apply for recertification. And so it's another time that the Homeland Security looks very closely at what you're doing as a school. So it's a hard process to get initially certified, and then it's very burdensome to stay certified.
Mhm. So it sounds like we've got a lot of different players here. We have the host institution, we have the students, and we have the government that all play a role in managing these foreign student programs. Can you explain sort of more specifically what are the requirements and roles for the institutions? What are the requirements on the students and the government when we talk about somebody maintaining that status?
Sure. So, very generally speaking, students provide information to the designated school official. That's generally speaking, that's going to be their international student advisor, right? Those are the ones who are generally the designated school officials. And the designated school official is a term that Homeland Security uses because they have also certified the DSOs. But so anyway, the student generally provides information to the DSO, and the DSO updates the SEVIS record and manages it. The student does not have access to the SEVIS record. And as I said before, it's a huge amount of work, and there are regular reporting deadlines that the school has to go through, and there are major consequences for any mistakes. So schools take this very seriously. They get a lot of training. The Department of Homeland Security has some training online. NAFSA has, very detailed advisor's manual that people use. We have an upcoming conference where we'll all be talking about, keeping up to date and best practices and so forth. But so yes, so it's again, student provides information, DSO manages the student's record for the school, and then Homeland Security is sort of on the back end looking at everything that comes into the SEVIS system. Yeah, so the kinds of changes, I sorry, I should have mentioned this earlier. The kinds of changes that a designated school official might enter in the SEVIS record of a student, again, would be a change of address. The government always wants to know what your physical address is. Change of major. You could do what we call a change of level, which is, for example, you finish the master's and you go on to a PhD. That would be the change of level, and just many other kinds of actions that students take are tracked by this system.
So there's a lot of responsibility, it sounds like, on the institution to let Homeland Security know how all of its students are tracked. Let's ask maybe a broader question. Approximately how many institutions are hosting students, and how many students are there in the U.S. at any given time?
The last numbers I saw on students was around a million.
Okay, so
So around a million students. I should know, but I don't exactly how many institutions host them. I saw numbers the other day that there are about 6,000 higher ed institutions in the U.S., and I just would have to assume that the vast majority of them do. There is a good report on the DHS website, and the specific area of the website dedicated to these issues that we're talking about today is called Study in the States. And they have a report called SEVIS by the Numbers, where you can find a lot of detailed data on how many students and where they are and so forth, what their majors are, all that kind of information. But it would be
it would
thousands
be
if that's
thousands for
helpful.
sure.
Yeah.
Lots and lots. Okay.
Yeah, lots.
So let's talk now about what's happened in the new administration, that's different from how things have operated before. Can you tell us what specific actions the Trump administration has taken regarding foreign student status, and how those actions differ from the policies of previous administrations, and maybe how you think they will affect foreign students in the U.S. in the future?
Sure. So this is a rapidly developing situation, and stop me if I say things that are confusing here. But we're basically seeing two strategies from the government: mass revocations of visas and mass terminations of SEVIS records. And the visa again is a travel document that allows you to come to the U.S. and apply for what's called admission to the U.S. So it's just a travel document. And then the SEVIS record is basically your whole life as an F1 student in this database that you're required to be in. So we're seeing mass revocations of visas, mass terminations of SEVIS records. Now, Department of State has from time to time over the years revoked a student's visa. It would be very rare. And there are a couple of types. I won't get into this, but there are a couple of types of visa revocation described in the Department of State Foreign Affairs Manual. But basically, we didn't see many. I've been in the field probably 25 years and have just seen very few visa revocations. However, when the first Trump administration implemented what they called extreme vetting, we did see an increase in the numbers of visa revocations. Almost all of them were the result of a DUI charge. And I say charge carefully, not necessarily a conviction. So, for instance, a student would be charged with DUI, and then sometime soon after that would get an email from Department of State saying, your visa has been canceled. And again, to make a very long story short, when these started happening, obviously the students were scared. They wondered if they could stay. The advisors were scared. They didn't know how to advise the students. So we had many discussions with all of the agencies involved, Homeland Security and Department of State, and many conference sessions where they came and presented and so forth. And the key takeaway was those students with a revoked visa could stay in the U.S. Their immigration status, their F1 status, was not terminated. Only their visa was. So when they needed to leave the U.S., they would need to get a new visa to come back. And it's difficult when you've had a DUI, and that's a whole other kind of a
Right,
podcast,
right.
but difficult situation. And so, that wasn't a tragic, catastrophic ending for the students, right? Like it was a problem, but they could stay here and finish their studies and so forth. Now, the mass revocations of visas that we're seeing now are completely different. The students get email message, and it goes to the email address that they used when they applied for the visa the first time. And as you all know, if you've gone to university, sometimes you stop using your old email address and you might start using your new
Mhm.
email address that the school gives you. But in any case, the State Department sends a message to the student saying your visa has been revoked, and then it contains a lot of very scary language. It says you are now removable. If you stay, you may be subject to fines, detention, or deportation. That's a specific quote: fines, detention, and or deportation, and you should leave the US immediately. So this is very different than the prior visa revocations that we saw related to DUI. And I can go into this in more detail, but I can just tell you that for the most part, students are very confused about what they might have done to get these revocations.
Mhm.
Okay, so that's part one: visa revocations. Big
Yeah.
problem,
And
massive.
that's on the State Department side.
Exactly.
Right.
Thank you. State
So
Department is
so
doing
there's
that.
something else happened on the CVIS side, the DHS side too. What's going on there?
Exactly. And so that's the Department of Homeland Security, of course. And so the SEVIS records are being terminated in many, many students' cases. And so this is extraordinarily rare. I've never heard it happening well, I've been in the field 25 years, but SEVIS has only been around about 21 or 22 years. So I've never heard of it happening. And this, not working at a university or in private practice or working at NAFSA. And it would be huge news if it happened. So if it ever happened, it was extraordinarily rare and none of us have ever heard of it. And when I say it, I mean the SEVIS record being canceled by the government. There are reasons that a designated school official would terminate a SEVIS record. Now, these are rare. And because the DSOs know that this is kind of a nuclear option, they are very, very careful in doing so. And for example, if a student died, which is a terrible situation, obviously that student's SEVIS record would need to be terminated. If the student decided to quit school and return home, that student's SEVIS record would need to be terminated. If the student was suspended from school for some reason, the student's record would be terminated. So DSOs can do this. They all have probably had to do it a few times, but it's extremely rare and it's a big deal for them. So they know who they've terminated. So it would be very rare for a designated school official to say, hey, I'm going to run a SEVIS report to see if there are any terminated students. It's just pretty
And they
rare
wouldn't
because
do
they
that
know.
because ordinarily the termination would come from them, so they would know.
Exactly.
But now
Exactly.
what's happening differently?
Yeah. So apparently, a few weeks ago, for reasons I don't know, a designated school official ran a report of terminated SEVIS records and said, wow, there's something unusual going on. We have these SEVIS records terminated, and there's a strange reason in the box. We didn't terminate it, and there's a strange reason listed in the reason termination reason box. And she was shocked and told some other designated school officials, and they all started checking their records. And pretty soon, it kind of spread like a virus that hundreds and hundreds and hundreds of records had been terminated. Roughly about 2,000 of these have been reported to NAFSA. We have a tool that we collect information about the terminated records or visa revocations. We've got roughly about 2,000 reports. And I've seen others, Ayla and others have quoted 4,700 people being affected. And I don't doubt those numbers, but I just don't know where they come from. And not to get off on a whole other topic, but our numbers could be a little bit lower because we require you to know a lot of information about the case and the student and the termination reason. And DSOs are swamped right now with all of this going on. So we may not be seeing all of the numbers reported to us. But in any case, we started seeing two kinds of SEVIS terminations, the reasons listed in the reason box. I don't want to go too much into the detail about this, but we saw one type where they listed a ground from the Immigration and Nationality Act that makes somebody removable from the U.S., deportable from the U.S., and it's a ground related to, quote, potentially serious foreign policy consequences for the U.S. We've all heard about this in the news, right? That's another reason that they're using in the cases that have hit the news.
And that's similar to the reason that the State Department has been revoking some of the
We
visas,
think
correct?
so,
Okay.
right? And so we saw these revocations and terminations happening, and I thought, aha, so those are related to people who've protested or been involved in, I don't know, inflammatory discussions on social media about various topics. But pretty soon, designated school officials were saying, no, my students has not protested, has not had any social media engagement and so forth. So then we were very confused about that termination reason. We were seeing a second termination reason, which is just a very general ground in the Immigration and Nationality Act that basically says you've violated your status. And sometimes the reason would also say something like criminal database check. And so he said, there are two kinds of denials. There's one for foreign policy grounds, and there's one for criminal database checks. And again, people were scrambling and trying to figure out, like, well, I don't, students would say, I have, I got a couple of speeding tickets. I don't know, like, is that what this is about? So anyway, lots and lots of confusion. And then one day, about, I don't know, 10 days ago, all the DSOs came in to work, started checking their SEVIS termination reports, which they're now running, of course,
Regularly,
daily,
yeah.
some of them hourly. They're all
Mhm.
just scared. And the reasons had all changed in SEVIS overnight. The termination reasons had changed to other. And so it's very strange that they started out citing these very specific citations from the Immigration and Nationality Act. And then I don't know if somebody thought better of it, or if maybe they talked to a lawyer who said, no, those are wrong. And overnight, they all changed to other in the database. And so all of the terminations that we're seeing now are for reason other, and literally many of the people with revoked visas and terminated SEVIS records have absolutely no idea what they've done. There have been no specific allegations of any kind.
Right. So we have this situation where somebody's visa, previous to this, somebody's visa may have been revoked, but the government said, yes, but you can finish your study. Just when you leave, you have to go try to get a new visa. And because of the reason we revoked it, it may be harder to come back. Now they're both revoking the visa and terminating the status in SEVIS, which basically means the people are out of status completely in the United States. And some of them have encountered ICE already, and some are just sort of waiting, or have they had any communication from the government at all?
This is such a great question, and thank you for summarizing the situation so well. So, when you get the revoked visa, you hear that from Department of State. When you get the terminated CVIS record, all you hear it from is your designated school official who happened to do an unusual check of the database. Nothing from the Department of Homeland Security, no specific allegations, no here's what you did, none of that you usually expect in American jurisprudence, right? And there's a very long discussion, and maybe this would, some immigration lawyers handling these cases can talk about this. Whether it ends your status is a very
Hmm.
complicated illegal question that's been very fun and interesting to talk with lawyers about. But you're absolutely right that it ends your ability to remain in the US and do things, right? Because when that CVIS record is terminated, like let's say if you want to travel home to visit your family, you need to get a new visa eligibility document form I-20 that the designated school official signs to say you're allowed to travel. You can't get that. If you're going to graduate and go on to practical training, you can't do that because that happens through CVIS. If you want to change from bachelor's degree to master's degree, you can't do that because that happens in CVIS. So I'm trying to be careful about
Hmm.
the language. So it sort of ends your immigration life as a student. And then there's a very complicated question that's being argued in these cases about whether it ends your status. But it is catastrophic for the students.
Right.
Absolutely.
So, how are the educational institutions responding to these changes, and what challenges are they facing in adapting to what appears to be new policies, but maybe it's unclear whether they're new policies or not?
Yeah, this is a whole new approach. As I said, nobody has ever seen this happen before. Where the government's terminating CVIS records, and as I said before, when we in the prior Trump administration, when we saw the visa revocations, they were very different. Nobody was alleging that you were going to be fined or removed from the U.S. So this is very different, and obviously the clearest effect is fear. Students are scared to death. In a lot of cases, they have no idea what they're being accused of. The designated school officials that advise them, they're not lawyers, and even a few do or have been lawyers, but they don't work as lawyers on their campus, so they can't provide them legal advice. And so, we've been strongly encouraging designated school officials to work with their legal counsel on their campus to figure out how to assist the students, and then also how to be careful so that nobody wants to be accused of obstructing a federal investigation,
Hmm.
right? And that
Hmm.
seems extreme, but in this current environment, maybe not. So we're strongly encouraging advisors, designated school officials to talk about this with their general counsel, get some ground rules, get some standardized approaches. And, I say that having worked with a lot of general counsels over the years, and having worked on campuses, and knowing that their day is filled with, hundreds of different kinds of legal issues. I don't know, everything from real estate deals to maybe tenure fights and things like that. And so this is just another thing on their
Hmm.
plate. But I think a lot of our members of NAFSA who didn't already know their institutional counsel well are getting to know them well.
Yeah.
And then, as I said before, the other thing that this is doing is it's preventing students to doing things that they seem to have the right to, like practical training. When a student finishes a degree, they really value this opportunity they have to go out and gain some experiential learning, some practical experience in their field. And they can't even apply for the work card that they have to get to do that experiential learning because the CVIS system won't let them, because it's basically terminated them. As I said before, they can't change level and so forth. So fear, inability to do what we think they have the right to do. And then finally, a lot of schools, we at NAFSA are wondering, will prospective students still want to come to the US now that they're hearing about all this in the
Hmm.
news? They contribute almost $44 billion a year to the US, and they support about 380,000 jobs. And this is all, if you want to know more details about their contributions to the US economy, NAFSA has an economic value tool that breaks this all down by state and so forth. So anyway, huge contribution to the US, huge contributions to the universities. They pay tuition.
Hmm.
Many universities charge an international student fee for administering this program. So lots of terrible impacts to come from this, and we're really worried about the future. Just as, by the way, we have Canada and others just out competing us for students
Right, right.
already.
So, what is your organization doing to sort of make your case to the administration and lawmakers about the changes that are happening?
Yes, so we are. Oh, and if I can back up,
Sure,
Teresa, I
sure.
also forgot. I forgot to mention that there was a news report couple of weeks ago about the Department of Homeland Security threatening to take away a school's certification. And I talked earlier about that
Mm-hmm.
complicated process you have to go through to get certified to host international students. So there have been threats that DHS may take that away from schools. And already schools have to apply every 2 years for recertification. And so there are concerns that DHS might just say, thank you for your recertification application. We've decided not to recertify you. So that's another one of the fears, by the way.
Mm-hmm.
So
Yeah.
just wanted to make sure that was
Yeah.
clear.
So, fears on behalf of students, institutional fears as well. So, with all this fear, what are you doing
Yeah,
as an organization?
absolutely. Great question. So we are doing a lot of things. I'll just try to run through quickly. We're gathering data. So first of all, we're trying to see the outlines of the problem, right? We talked to some people early in the process who thought, well, like, this is probably just affecting the sort of so-called liberal institutions in the New England area, and it was quickly obvious that that was not the case, or it's only affecting students from certain countries, for instance, predominantly Muslim countries. Not the case at all. So anyway, it was very important just to start collecting some of this information and make sure we were seeing the contours. And as I said before, our tool requires people to put in some information, and it's a little bit more than just a 30-second situation. So we may not be seeing all the numbers, but we have roughly about 2,000 reports, and it seems to be going up every day. But we're collecting that. We have a lot of resources for members, and they range from our advisor's manual, which is a fantastic resource. I can say that, I think, not because I work at NAFSA, because I used it when I was in private practice, and previously it was just a great resource for advisors to know the law, the agency policy, and so forth. We're also doing webinars. We have one today with a couple of lawyers who are handling these cases and having some good early success against the government in these cases. We always have had liaison with the agency officials. I mean, that's in my title, so it's one of the things that I do. And right now, it seems to be dead. I hope that's temporarily, but
So, the
we
government has said we're no longer conducting these liaison meetings.
Yeah, and even more, to be more accurate, I guess I should be accurate. They are just not not returning our calls and
Hmm.
emails. And these are people that we've worked closely with over the years. They find a lot of value in what we can bring to them, because we have 6,000 or so members telling us what's happening, and we obviously like to hear from them, and we can get out the word to our people about changes in policies and procedures and so forth. And I think they're just scared to talk. We saw that in the previous Trump administration some, but we still had decent liaison then. But now, I guess if you're coming to work every day as a government official and not knowing whether you're going to be locked out, or whether AI is listening to your phone calls or something, I guess people are scared to death. But anyway, so we're still putting those resources out. We're still doing all kinds of different information for our members, and we're still going to keep trying to do liaison with the agencies, but it seems dead. We're discussing with members of Congress and their staffs what's going on. We recently had an outstanding meeting with some super well informed staff members from people on the Hill who knew all about this and were interested in getting some input from us. We are working with colleague associations. There are quite a few of us in this area of education, generally speaking, and we work closely with them on, how can we support the litigation, mostly with information. I don't know if at some point it comes to, well, some of those associations are plaintiffs in
Hmm.
litigation
Hmm.
now, and others have filed amicus briefs in litigation. So we're doing all that. We're constantly in communication with the other associations, and these include American Immigration Lawyers Association, NACUA is the National Association of College and University Attorneys, and we're discussing issues with them and with many of the lawyers handling the cases. My colleague and I are on a lot of the email chains with them and just trying to provide whatever informational background we can
Yeah.
provide them. And then finally, I'll mention that my beleaguered colleague who handles our media relations is constantly, in touch with the media. And I have to give her credit. As I say, I've been in this field about 25 years, and I can say that sometimes it's a difficult field for the media to understand. Just like as you and we've been
Right.
discussing all these acronyms and things,
Yeah.
and it's easy for them to get it wrong. And I've never seen them get it so right. And I attribute a lot of that to my colleague who handles our media relations. She's done a fantastic job of providing them with information, and our CEO Fanta Aw has been out all over the media as well,
Yeah.
explaining
Yeah.
things.
So, as we said at the beginning, this is something that is happening now and kind of changing on a daily basis. So, I really appreciate you coming on the podcast to kind of give your sense of how this system has been working and help our listeners understand sort of what these changes have been. And as things proceed, we may have you back on for a follow up to see where things land. But thank you so much, Steve, for being on the podcast today.
Sounds good. Thank you, Teresa. Thanks for your interest in this and for the opportunity to speak with you.
Okay, so we're going to take a quick break on the podcast, but when we come back, we'll talk to Charles Kuck, a preeminent immigration attorney who has filed suit against the administration on behalf of 17 students who had their status terminated. So stay tuned. Welcome back. I'm happy now to welcome to the podcast Charles Kuck. Charles is the managing partner at Kuck Baxter Immigration LLC in Atlanta, Georgia, where he oversees an extensive immigration practice. With over 35 years of experience, Charles specializes in business and professional visas, labor certifications, immigrant visas, consular representation, and citizenship matters. He has also represented clients in over 700 trials before immigration courts and maintains an active federal court practice, which we're going to talk about with him today. He's also a professor of immigration law at Emory University School of Law and the University of Georgia School of Law. He is recognized as one of the top immigration lawyers globally and somebody who taught me immigration law way back in the day. He is a frequent speaker and writer on immigration issues as well. So welcome to the podcast, Chuck.
Teresa, it's a pleasure to be with you and wonderful to see you again.
It's good to see you as well. So thank you so much for joining us. So we invited you on because you recently filed a lawsuit against the Trump administration on behalf of 17 foreign students on visas in the United States who had their status terminated by Immigration and Customs Enforcement. So first, can you provide an overview of the case and the circumstances that you understand led to the rescinding of these status?
I'd love to. I would first start by saying there are now 133 plaintiffs in our lawsuit. We amended our complaint earlier this week. This is a very strange set of circumstances of what happened to these students. Around April 1st, my understanding is a designated school officer, or DSO, at a small college in the Northeast was checking something in the SEVIS registration package that they have access to, and she noticed that a couple of her students had been terminated, and she had knew nothing about that. So she called a friend, and that friend checked, and she also had some terminated. And pretty soon, all the DSOs in America are finding out that a whole bunch of their students are terminated. They had received no notification, so they reached out to the students, and they said, "Hey, your SEVIS was terminated. What's going on?" And the students are going, "I don't know. I don't know what's happening." The terminations had one or two or three different vague reasons, including the word other. That was my favorite termination. Other, failure to maintain status. Well, as many immigration listeners know, there's very specific things you have to do to fail to maintain your status as a student. And the school would be aware of virtually every single one of those, like not taking enough classes or failing your grades or not going to class. They know these things. So it seemed very strange. And they also said criminal record checks. Now, the odd thing, if you go to Study in the States, which is the website that ICE runs for the SEVIS program out of SEVP, the idea of criminal record checks is not in there as a basis of termination. The last basis that we saw was visa revoked. And again, that's actually not a basis to terminate SEVIS, that a visa is revoked. So what students then began receiving, some of them, not all of them, emails from their consulate that said, "Your visa is revoked, leave the country in 15 days. Well, as you can imagine, at the end of the semester at most schools, these kids are panicking. Many are graduating. Many of them work on OPT and CPT. So they began trying to find out what was going on. And schools, they were at a loss. They had never seen this before. So I had a DSO reach out to me from a university here in Georgia and said, "Hey, Chuck, what's going on here?" So we did a little investigation and realized that ICE had moved their operation to get people to leave the country from picking people up and deporting them to basically scaring them into leaving. That's what we think this really is. It appears to those of us on the outside that are doing some of this litigation that ICE's AI has been at work, because there's, near as we can tell, there's anywhere from 4,000 to 6,000 of these students who received these termination notices. And that's not done by one person in a cubicle at ICE headquarters. It's clearly done by AI. And our guess is they went to AI and said, "Hey, here's a list of all the students. Run these names against every known record database where fingerprints were taken of any kind." And that includes both immigration and criminal and civil databases. And anybody who got a hit, regardless of how long ago it was, regardless of whether the student had left and re-entered and got a new visa, they sent out these terminated notices on CIVIS. So that's where the students found themselves beginning around April 1st, although we do have one from March 29th, but it really began in earnest on April 1, and they're still going on today.
So for our listeners who aren't as familiar with the intricacies of immigration law, can you explain sort of, let's say somebody did have a run-in with the law maybe years ago, would that automatically mean that they would be not eligible to get a visa? Could they come in anyway? Doesn't matter how long ago, what kinds of things or would not lead to that? I mean, again, the government's talking about anybody with a criminal record should not be here, but like, what does the law actually say?
Well, the law doesn't say that.
Okay.
We have this really cool thing in America called the Constitution that basically says you're innocent until proven guilty. And I know this may shock some of your listeners, but the police arrest innocent people all the time. And even if they're arrested correctly, prosecutors don't prosecute every crime. For that reason, our immigration laws are written based on convictions, not on arrests. And so we're talking about the age group between 18 and 25, essentially. These are the foreign students. And I don't know if you've been an 18 or 25-year-old or you have any. Both apply to me. They tend to do dumb things sometimes. They just do. For example, a couple of our plaintiffs, this may shock you, were arrested for public drunkenness. I know it's shocking.
That doesn't happen on college campuses, does it?
Of course not. It's very rare, very rare. And no charges were filed. They were arrested and they were let go. And we've seen other crimes. We've seen minor shoplifting stuff that was let go. We've seen DUIs that were not prosecuted as DUIs, ultimately as reckless driving. And this is why our laws are written the way they are. Somebody's not a criminal because they do something stupid one time. Apparently in America in 2025, we love labeling things as permanent. Just because you did something dumb one time doesn't make you permanently dumb. It doesn't make you permanently a criminal. And the idea that you can't make any mistakes. If you come to America as an immigrant and you must be, I don't know, Jesus. And if you're not Jesus, you're going to be deported. That's an insane standard to hold any human being to. And none of our clients, none of the 133 clients that we filed on behalf of, have a criminal conviction that renders them out of status, which means they violated their status, or removable from the United States.
Okay. So these minor infractions, particularly the ones that were not prosecuted, are not, under the immigration law as it stands today, grounds for deportation.
No. And what's interesting, and a couple of our plaintiffs had incidences when they were some of them older, like we have a couple 35-year-olds. They were here as a student in 2013, and one of our clients got a DUI in 2013. Nothing happened. He finished school, graduated, went back home. 10 years later, he says, "I'm going to get an MBA." So he goes to the consulate, discloses everything. They said, "Great, no problem. You're good. Have a great day." Gave him a visa, came back. That is his only encounter with immigration was that, and he got a revocation. Now that makes no sense whatsoever. Another one of our plaintiffs, interestingly enough, cannot figure out why she got this. She's never been arrested. She's never had an immigration violation. She's literally not on social media. So she's not one of the folks they're going after on social media posts. We just literally can't figure it out. And I'll just say one last person that we had. She had an immigration violation in 2017, and she was turned around at the airport. I mean, sometimes you come into the airport and the friendly guys in the black uniforms and the guns, they're not going to let you in. They go. So she didn't get an expedited removal. She withdrew, went home, went back to the consulate. They dealt with the issue, came back in. That was 8 years ago.
So just to clarify again, because none of our listeners understand all this procedural stuff. Yeah. Some of the clients that you represent may have had something in the past, but they went back to the consulate. A consular officer reviewed the entire record and said, this does not make you, in our mind, ineligible to come back or to come into the country. They issued the visa. They were admitted when they came back in, which means CBP at the port of entry also said, we find you admissible. And now they're being told, actually, wait a minute, no, now we think you're not.
We changed our mind, not based on law. Yes, that's exactly what happened.
Okay. All right. Just trying to be clear about this. And you mentioned, one of your students, somebody who didn't have social media. I mean, that's another reason that we're in the news, at least people are talking about some of these visa revocations are based on people who participated in protests or said something on social media in support of, the Hamas movement or something. Those are the allegations. For your clients in this particular case, that seems not to apply to any of them.
Doesn't apply to any of them near as we can tell. Now, the other interesting thing that happened, and one of the reasons they gave on some terminations were your visa was revoked. Well, here's what we're finding out. Why was the visa revoked? Because ICE gave a list to the consulates of the students' SEVIS they terminated. So
it's a circular kind of thing.
It's a circular argument. In fact, yesterday in oral argument, the government said, well, they had their visas revoked. And when I went back up, I said, Judge, they had them revoked because they canceled their SEVIS. And she was like, that makes no sense. I said, that's why we're standing here today. Does none of this make sense?
Okay. So that answers a question that I was going to ask you. Like, what prompted you personally? I mean, I know you do a lot of litigation, but why did you take this particular litigation on?
Honestly, because it pissed me off. I'm at the stage in my career after 35, 36 years. I can do stuff and fight for people just because I tick me off. This is unfair. There is nothing worse to me than unfairness. You have an extraordinarily vulnerable population of people here. Yesterday, after the argument, a woman came up to me, and she's an older woman. She's not known to our place, and she was just there in court. She says, "Thank you for standing up for our children." 18 to 25-year-olds, their mom and dad kiss them goodbye. They're going to go to the greatest country in the world to participate in the greatest education system in the world. And maybe they made a stupid mistake at some point, but not something that's going to change their life. And now they're being told, leave a week before graduation, leave before you complete your practical training, leave before your dream is fulfilled. That just ticked me off. That's not fair. There are people that got this that are deportable. All right, that's the way life is. You do a deportable offense, you're going to bear the burden. We're fighting for people who are not deportable, trying to restore the status quo. The judge asked me in oral argument yesterday, what do you want me to do? I said, Judge, I want you to put them back to where they were. You can't restore their innocence. You can't restore their lost hope in America, their frustration, but you can at least make them legal again, at least in the eyes of the law. She says, okay.
Yeah. So let's talk about the legal arguments here. What did the government say in response to your litigation? What were their main legal arguments to justify rescinding the status of these students?
I'm smiling because their legal arguments were odd. Our argument is centered on a couple of things. One, we're not challenging visa revocations. There's a Supreme Court case on this.
It's very hard to challenge a visa revocation.
So we just said we're not challenging that. Just right up front in our complaint, we're not challenging that. The very first 4 pages of their response to the court was talking about how we can't challenge the visa revocation. Yeah, I just got to say, I agree. Next. The next 3 pages of their brief were about why we can't file under the Privacy Act, which is not a part of our complaint. We're not filing under the Privacy Act. And then the last part of their complaint was basically arguing that our clients were still in status, that the SEVIS cancellation was a giant nothing burger. That's basically what they said. It's a nothing burger. It doesn't really mean anything. And those letters they got from the State Department, that's not us. That's not DHS. That's state doing their thing. But not really our problem. It was strange.
So were they saying these folks are not being deported and don't have to leave
Yes.
within the 12 days or whatever that the State Department email said?
Correct. There is no legal requirement if your visa is canceled that you leave. That's no legal. The visa is used to enter the United States.
Right.
Once you enter the United States, the visa becomes irrelevant, and you are in status. It's your status that matters.
Mm-hmm.
Their argument that our clients were still in status was wildly disingenuous, according to their own policies on CVP, on SEVIS.
Right.
Because, for example, SEVIS termination means that if you're working on OPT, CPT, you can't. You can't work on OPT, CPT.
Yeah, and that's the optional curricular practical training that goes along
and during
with
school too.
Right.
You can't change your status. So we have about, I think, 10 of our clients won the H-1B lottery, and a couple of them had pending cases. One of them has already received a notice to deny, saying your SEVIS was terminated. So you can't, with a straight face, say your clients are still in status when they're clearly not treated as if they're still in status. The very oddest thing that they argued, and this actually ticked off a number of my DSO, the school officers, when I told them about this yesterday, the hearing, they said they can just file for reinstatement. Now, there's a program under, let me take a step back. There are multiple reasons to have your SEVIS terminated, which are legitimate. You dropped out of school. You got sick. You couldn't go to classes. You failed all your classes. Those are all legitimate reasons. And so there is a reinstatement policy that you get back in status so you can explain what happened. That reinstatement policy requires submission of forms, a lot of work. And it usually takes 6 months to be adjudicated. Well, one of my DSO, before we filed the lawsuit, I talked to a DSO and said, what about reinstatement? She said, I called the help desk. This is the help desk for SEVIS, and said, what about reinstatement? And I was told they're not going to reinstate any of these students. So now you have the U.S. attorney arguing that they can be reinstated in the same breath that they're arguing that they're not out of status. Well, I always had a chance to get up and rebuttal. I said, I don't know if you know this, Judge. Probably don't. And she was like, Mr. Kuck, I don't know anything about immigration law, which is not surprising, by the way.
A lot of federal judges
I said, well, Judge, one of the requirements to be reinstated is that you be out of status. It's actually a legal requirement. The government is arguing from both sides of their mouth. It's wildly disingenuous to suggest they can reinstate when they are legally, they're arguing at the same time, they're not out of status, so they can't reinstate.
Yeah. So I think you've already addressed some of this, but what are the main points of your counter arguments? What are you arguing and what are you asking for from the court here?
So what we're asking, first of all, we ask for a temporary restraining order, which is immediate relief. To get immediate relief is a high standard. You have to show what's called, and the government talked about this a lot, irreparable harm. They said it's not irreparable harm to lose your job. It's not irreparable harm not to be able to pay your rent. It's not irreparable harm to have to change schools. It's not mental health issues or emotional issues aren't irreparable harm. I said, Judge, yeah, on each of those things. But taken together with all of those things happening, yes, that is the very definition of irreparable harm. And then I said this, Judge, I don't know if you changed colleges when you were going through school, but it's really hard to transfer credits from one school to another. In fact, it's almost impossible country to country. And that's what the government is suggesting today. She's not in her head as I'm saying this. So they were suggesting that. And it was honestly, I think it was a result of the U.S. attorney also not understanding this very complicated area of immigration law. In fact, you and I both know, there's not a lot of lawyers that do F1s.
Yeah.
It's almost all NAFSA. It's almost all DSOs, foreign student advisors, that do most of the work in this area.
Yeah.
So it's no wonder they didn't know anything about it.
Yeah. And as I mentioned, we talked to Steve Springer from NAFSA who walked through this, and it is complicated and there's a lot of players. So you had this preliminary hearing before the judge. I assume it was on the temporary restraining order.
Right.
When do you expect to hear on that? And then what's sort of the steps in this case? Where would it go from here?
Okay, so we asked the judge to reinstate their status. By the way, there have been at least to date 10 other judges that have done this already. And we confirmed this morning that ICE did in fact reinstate their SEVIS. They did it. It's already been done. So we know it can be done. So we ask you to reinstate their status, and as a result, these kids can go back to work. That's boom. That's the ask. And the second step is, and she said she was going to make a decision from the bench. I think she was going to grant it. She basically said she was going to grant it. But then the government wanted more time to respond to something that we did was a bit different. We don't just have Georgia plaintiffs in our case. Our plaintiffs are from all over the United States. We have 40 different schools, 25 different states. And we had to make an argument that it was appropriate under federal venue and joinder rules for that. And of course it is. I wouldn't have filed it if I didn't think the client's qualified for it. And I filed many multi-plaintiff lawsuits in singular jurisdictions where they don't live without a problem. But the government wanted time to respond to that. And they asked for a day today, and the court said by 5. And the government lawyer was like, well, Judge, typically we have till midnight. Here in Georgia, it's Good Friday, by the way. Many places are closed. So she gave him till midnight. I suspect that we will get the judge's decision shortly after midnight, is my guess. Because there's nothing he's going to say that would say that our out of state applicants don't qualify to be part of this case. There are very specific rules on this. But the judge, at the same time she said that, says, well, I want to do a very quick injunction hearing on this. The next step is an injunction, preliminary permanent injunction. So she set that for Thursday. It was at 11. Now it's at 1:30 in the afternoon this following Thursday. Now, the interesting thing is we spent 2 hours in oral argument on this. It's the same argument. So it should be a relatively quicker hearing, although now that we have found additional evidence that we're going to be submitting, including the fact that they didn't reinstate people, and that we're getting more information about what's kind of going on with this. One of the things we did learn, though, through this is that not every DSO, not every foreign student advisor understands what happens when somebody's status is is terminated. Mm-hmm. Some schools said, hey, you can't work, OPT, CPT, go talk to a lawyer. Some other schools wrote to the students and said, leave the country now, which is not a requirement. Right. So hopefully what comes out of this, besides getting a permanent injunction and restoring our students, is that there'll be some greater education about what it means when SEVIS is terminated. And the reason is the schools think that way is that, look, if you fell out of status, you have a status issue.
Right.
But these kids didn't really do that. So kind of a unique situation.
Yeah. I mean, one of the things Steve said is that for most DSOs, the only time SEVIS is terminated is when they tell SEVIS to terminate a student because they know that student has been kicked out of school or dropped out of school or is no longer taking a full course or maybe worked without authorization. Any of those could result. So they're the ones who asked for the termination. So they would assume, yeah, I'm asking for the termination because they're no longer in status. This is sort of the reverse. The termination happened without any lack of a failure to maintain status.
What's interesting about that is after the hearing, another lawyer found a policy memo that went out to DSOs in 2018 under Trump. And it said this: if you DSOs find out your students have been arrested for something, it's your obligation to investigate it and see if we should be involved. So right. Typically terminations always come from the DSOs. So that's what's very unusual about this case. And we're going to be submitting that in this next week. Say, Judge, they just don't even follow their own rules. And ultimately, that's what we're asking for. Look, if a student, does something that gets them terminated that's legal, okay, that's fine. Follow the rules. This is an administration that does not want to follow the rules because they're inconvenient. And, I still live in a country of laws. I like to believe I live in a country of laws. Fourth Circuit thinks we still live in a country of laws. Let's force the government to live by them.
Yeah. So, you have 133 plaintiffs in this case. You noted that there are other court cases going on in other parts of the country with other plaintiffs. Mm-hmm. What do you think this case or this series of cases could mean for other foreign students in the United States? One of the things we hear a lot about are class actions. Is that potentially on the table? Is there a broader sort of, okay, your clients get reinstatement and made whole, but is there a way to sort of say, government, you need to stop this thing that you're doing generally? How do you see that proceeding?
Well, we filed for 133, but we have 250 more clients that want to sue. We're just waiting until after the court rules on this case. So I've been thinking all day today, should I turn this into a class action? Because it's inherently unfair that just because you hired a lawyer, you got fixed, but all these other kids didn't. I mean, that's kind of unfair, and what unfairness really ticks me off. So we may be doing a class action if we don't just do the mass action. I think that would solve the jurisdictional issue for the court, and we would just file it again in Georgia. And if we file the same factual case, same legal case, it's going to be referred to the same judge. So we've been back in front of Judge Calvert again this next week after our next hearing on behalf of all these other students. But that's the thing here. Any other administration would say, you're right. That was just stupid. We should have done that. That doesn't happen here. There is a class filing out of Pittsburgh, but they didn't get a good selection on a judge, if you know what I mean. So hopefully they'll drop that and they'll let that filed somewhere else. And this morning I got an email from a lawyer locally, said, hey, I work for this person and I saw your complaint. Can you send me the claim I'm going to file? And that concerned me. And here's why it concerned me. These are very complicated cases. This is complicated law, complicated cases. A first-time lawyer filing his very first case on one of the most wildly complicated things I've ever dealt with is not a wise thing. So I reached out to him and said, look, call me. Call me before you file anything. If you don't know, if you're having to ask me how to write a complaint in federal court, this is not the case to file on. It's just not. So that's a concern you have, because as lawyers say, oh, there's success on this, I'll just take a case and file it. That doesn't mean it's going to be won. There had 2 cases of loss so far for the TRO, not permanently, but one in Michigan and one in Pennsylvania. I would tell you something interesting happened on one of these cases, Theresa. A case was filed in D.C. by Stephen Brown, and the judge was so ticked off at Andres Watson, who gave an affidavit in that case about students being status, that he ordered a deposition for Andres Watson to explain.
So Andres Watson, for our audience, is
ICE. He's the ICE. Yeah, who is he? He's like the senior guy over ICE for CVP. Yeah. But he's somebody referred to him as an operator. He's not a policy guy, right? So they get him to write this affidavit because he's a senior guy. Yeah. But somebody wrote this for him. He didn't write this. And so the deposition, I think, is this week. So I can't wait to see this deposition to find out where this is coming from. Yeah. That's the other thing. We could get discovery at a certain point. And we get discovery, we're going to find out what really happened here. And I'm not sure the government wants that to happen, honestly.
So any number of things can happen. Our listeners have been listening to this podcast a long time. We've covered a lot of litigation going back to first Trump administration, litigation against the Biden administration. There's lots of litigation happening in the immigration space right now. Some of it is, this whole policy, we want a nationwide injunction. Some of it is like yours on behalf of particular plaintiffs and clients, like we just need to fix their situation. But, as you mentioned, this litigation is just now everywhere and it's happening in lots of different courts. And so different courts may rule differently. Do you see this kind of thing getting to the Supreme Court, or are you hoping that, look, we'll settle this out before we get there?
This is a bad look for ICE. There is, they're not going to win this, and even in the 11th Circuit. Somebody said, why are you filing the 11th Circuit? Which is historically not a good place to file pro-immigration stuff. Look, this is just a pure legal challenge. Just follow the law. And the law is clear. I do not see them appealing these cases. And the fact that they're reinstating status on the TRO instead of immediately appealing it, I'm sure their lawyers are telling them, this is not that case. I'm not going to go ask for an emergency stay from the 11th Circuit on some kid's status being reinstated. Mm-hmm. Just do it. Just take care of it and do it. Much like the litigation we did with my friends Greg Siskin and Jesse Bless and Aaron Hall and Jeff Joseph against Trump on the fiancé visas back in 2019 and 2020 when they stopped issuing fiancé visas or the diversity lottery. Just do it. Just issue them and be done with it. Move on.
Yeah. Well, I think we'll end things there, but as the case progresses, we might have you back on to see where things are going. But Chuck Kuck, thank you so much for joining us on This Week in Immigration.
Theresa, it's a pleasure. Thank you for having me. I sure appreciate it.
And that's a wrap on this episode of This Week in Immigration. One last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find our podcast episodes on the Bipartisan Policy Center YouTube channel. You can find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow the Bipartisan Policy Center on the X platform at BPC_bipartisan. You can follow Theresa Cardinal Brown at BPC_T Brown, and you can follow me at Jack Malday. Send your comments and feedback to us by email to immigration@bipartisanpolicy.org. I'm Jack Malday. This Week in Immigration was created and executive produced by Theresa Cardinal Brown. This episode was written by myself and Theresa Cardinal Brown. Joshua Joe is our audio editor. Talk to you next time on This Week in Immigration.